All right, peace and blessings, everybody. May the 5th, the year 2018. Got a letter here from Daniel Riley. Let's read it. Danbury, Connecticut, April the 30th, 2018. Rudy and Aaron. This correspondence is for one purpose, to explain how Sessions versus DiMaya, decided April the 17th, 2018, affects prisoners. In 2015, the Supreme Court, in a case known as Johnson, struck down part of the violent felony definition found at 18 U.S.C. Section 924, parenthesis E, parenthesis 2, parenthesis B, parenthesis II. The part struck down stated, quote, otherwise involves conduct that presents a serious potential risk of physical injury to another, end quote. The Supreme Court ruled this language was unconstitutionally vague. The language is often referred to as the risk clause or residual clause. Johnson was a case that involved the Armed Career Criminal Act, ACCA. When a felon is charged with being in possession of a firearm, the max sentence he can receive is 10 years. But if the felon has has 3 prior felony convictions for a violent felony, the felon has to be sentenced to a minimum of 15 years. When looking back at prior convictions to determine if they are violent felonies, the court uses an analysis called the categorical approach. This analysis, according to the Supreme Court, is dictated by Congress because of the general terms used in the statute, like felony, convictions, etc. The statute basically does not ask to find circumstance-specific facts. The Supreme Court also has a concern that little mini-trials would be held in front of a judge to determine the underlying facts of how the crime was committed, and these facts would then be used to enhance the defendant's sentence in violation of the Sixth Amendment because a judge found the facts, not a jury. Since facts cannot be used to make the violent felony determination, the Supreme Court said the court must imagine the way a crime ordinarily is committed and then ask if a serious potential risk of physical injury existed. This way, the crime was either a violent felony. Come on, hold on just a second.
Physical injury existed. Have a look.
Okay, I don't know if that's gonna. Sometimes when I'm talking, my phone recognizes my voice and just goes off. Anyway, where was I? Let's back up again. And the facts would then be used to enhance the defendant's sentence in violation of the Sixth Amendment because a judge found the facts, not a jury. Since facts cannot be used to make a violent felony determination, the Supreme Court said the court must imagine the way a crime ordinarily is committed and then ask if a serious potential risk of injury existed. This way the crime was either a violent felony for everyone who commits it or not a violent felony regardless of how the crime was committed. The Supreme Court said that this was Congress's intent. The categorical approach acts like an on-off switch in this effect. This imagined crime, coupled with the imprecise risk standard, leads to too much indeterminacy, thus the vagueness conclusion. While arguing Johnson, the government warned the court that if it finds the risk clause of Section 924 parenthesis E unconstitutional, then the risk clause of Section 16 would be in jeopardy. Most statutes that entail a crime of violence within them incorporate the definition of a crime of violence found at 18 U.S.C. Section 16. The risk clause, part of the definition, is found at Section 16, parenthesis B, and states, quote, any other offense that is a felony and that by its nature involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense, end quote. This is identical to the risk clause of Section 924 parenthesis C found at Section 924 parenthesis C 3B. In DiMaya, the question was, did Johnson's reasoning also invalidate Section 16B? The government argued the language of Section 16B made the definition narrower, less vague. The court ruled the distinctive textual features were a distinction without a difference. The dual indeterminacies still existed. The judge imagined ordinary case and the imprecise risk standard. Therefore, Section 16b must fall too. The government argued if Section 16b falls, then Section 924C3b is put in jeopardy. Justice Thomas's dissent in DiMaya, like Johnson, urges the tossing of the categorical approach when applying the risk clause. Throughout these two cases, the government has agreed with the statutory construction the court has given these statutes. As the Supreme Court said in DiMaya, Section 16b's text, best read, demands the categorical approach. In other words, the way the statutes are worded is equivalent to Congress ordering the court to use the categorical approach. To throw out the categorical approach would overturn about 30 years of precedent. Now, Section 924C3b is up to bat. At the circuit court level, most have upheld it, while one circuit, Seventh, has struck it down. The circuits that upheld it used the textual distinctions to do so. We now know that DiMaya has dismissed that argument. The new premise these circuit courts have come up with to try and save Section 924C's risk clause is that the categorical approach does not apply to Section 924C cases because the offense is contemporaneous to the enhancement, unlike the ACCA, which looked at the stale convictions. These circuit courts completely disregard the Supreme Court's precedent that dictates they apply the categorical approach. These three cases, Leocal versus Ashcroft, 543 U.S. 1, 2004, Nijahawan versus Holder, 557 U.S. 29, 2009, and Descamps versus U.S. 1335 CT 2276, 2013, all determine the general words used in the statute like offense, felony by its nature, all show Congress's intent that it wanted crimes under this statute to fall into categories so all defendants are treated equally. Either the offense is a crime of violence for everyone who commits it or for no one. In a circumstance-specific analysis where the court looks to the facts of the way the crime was committed allows the same offense to be a crime of violence for some and not for others. In Nijahawan, the court interpreted a statute that required a circumstance-specific analysis. This statute explicitly says the fraud must have caused losses of $10,000 before it can be considered an aggravated felony. The Supreme Court determined the facts of the crime must be considered to find whether the loss amounted to $10,000 or not. There was many Section 924 (C) (3) (B) cases stayed pending DiMaya. In supplemental briefing, the government appears to now be arguing Justice Thomas's dissent, that the categorical approach should not apply, pushing the whole contemporaneous thing. As precedent stands right now, the categorical approach must apply to risk clause analysis. But these lower courts are mostly corrupt and want to side with the government so bad they may say to hell with the precedent and take the government's side. Decisions on whether DiMaya and Johnson invalidated Section 924 (C) (3) (B) will start coming out in the lower courts in the next few months, so we'll see what happens. The government's arguments to save Section 924 (C) (3) (B) are weak at best. Section 16b applies to contemporaneous offenses like Section 924 (C). The whole vagueness conclusion depends on whether the categorical approach applies or not. That is the question. If it's answered in the affirmative, the vagueness question is foregone concluded. I hoped this helped in your understanding of how DiMaya affects Section 924 (C) (3) (B). Daniel Riley. I am so glad and grateful that that Daniel Riley has a brain that understands what he just wrote. And if you understand what he just wrote, praise God for you. Thank you for your time.